of the legislative power, even by courts of states where the political rights of the colored race have been longest and most earnestly enforced. One of the earliest of these cases is that of Roberts versus City of Boston, which the Supreme Judicial Court of Massachusetts held that the General School Committee of Boston had power to make provision for the instruction of colored children in separate schools established exclusively for them, and to prohibit their attendance upon the other schools. The great principle, said Chief Justice Shaw, advanced by the learned and eloquent advocate for the plaintiff, Mr. Charles Sumner, is that by the Constitution and laws of Massachusetts, all persons, without distinction of age or sex, birth or color, origin or condition, are equal before the law. But when this great principle comes to be applied to the actual and various conditions of persons in society, it will not warrant the assertion that men and women are legally clothed with the same civil and political powers, and that children and adults are legally to have the same functions and be subject to the same treatment, but only that the rights of all, as they are settled and regulated by law, are equally entitled to the paternal consideration and protection of the law for their maintenance and security. It was held that the powers of the committee extended to the establishment of separate schools for children of different ages, sexes, and colors, and that they might also establish special schools for poor and neglected children who have become too old to attend the primary school and yet have not acquired the rudiments of learning to enable them to enter the ordinary schools. Similar laws have been enacted by Congress under its general power of legislation over the District of Columbia, as well as by the legislatures of many of the states, and have been generally, if not uniformly, sustained by the courts. Laws forbidding the intermarriage of the two races may be said in a technical sense to interfere with the freedom of contract, and yet have been universally recognized as within the police power of the state. The distinction between laws interfering with the political equality of the Negro and those requiring the separation of the two races in schools, theaters, and railway carriages has been frequently drawn by this court. Thus, in Strouder v. West Virginia, it was held that a law of West Virginia limiting to white male persons 21 years of age and citizens of the state the right to sit upon juries was a discrimination which implied a legal inferiority in civil society, which lessened the security of the right of the colored race, and was a step towards reducing them to a condition of servility. Indeed, the right of a colored man that, in the selection of jurors to pass upon his life, liberty, and property, there shall be no exclusion of his race, and no discrimination against them because of color, has been asserted in a number of cases. So, where the laws of a particular locality or the charter of a particular railway corporation has provided that no person shall be excluded from the cars on account of color, we have held that this meant that persons of color should travel in the same car as white ones, and that the enactment was not satisfied by the company providing cars assigned exclusively to people of color, though they were as good as those which they assigned exclusively to white persons. Upon the other hand, where a statute of Louisiana required those engaged in the transportation of passengers among the states to give to all persons traveling within that state, upon vessels employed in that business, equal rights and privileges in all parts of the vessel, without distinction on account of race or color, and subjected to an action for damages, the owner of such a vessel, who excluded colored persons on account of their color from the cabins set aside by him for the use of whites, it was held to be, so far as it applied to interstate commerce, unconstitutional and void. The court in this case, however, expressly disclaimed that it had anything whatever to do with the statute as a regulation of internal commerce, or affecting anything else than commerce among the states. In the civil rights cases, it was held that an act of Congress entitling all persons within the jurisdiction of the United States to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, and made applicable to citizens of every race and color, regardless of any previous condition of servitude, was unconstitutional and void, upon the ground that the 14th Amendment was prohibitory upon the states only, and the legislation authorized to be adopted by Congress for enforcing it was not direct legislation on matters respecting which the states were prohibited from making or enforcing certain laws or doing certain acts, but was corrective legislation, such as might be necessary or proper for counteracting and redressing the effect of such laws or acts. In delivering the opinion of the court, Mr. Justice Bradley observed that the 14th Amendment does not invest Congress with power to legislate upon subjects that are within the domain of state legislation, but to provide modes of relief against state legislation or state action of the kind referred to. It does not authorize Congress to create a code of municipal law for the regulation of private rights, but to provide modes of redress against the operation of state laws and the action of state officers, executive or judicial, when these are subversive of the fundamental rights specified in the amendment. Positive rights and privileges are undoubtedly secured by the 14th Amendment, but they are secured by way of prohibition against state laws and state proceedings affecting those rights and privileges, and by power given to Congress to legislate for the purpose of carrying such prohibition into effect. And such legislation must necessarily be predicated upon such supposed state laws or state proceedings and be directed to the correction of their operation and effect. Much nearer, and indeed almost directly in point, is the case of the Louisville N.O.N.T. Railway Company versus State, wherein the railway company was indicted for a violation of a statute of Mississippi, enacting that all railroads carrying passengers should provide equal but separate accommodations for the white and colored races by providing 2 or more passenger cars for each passenger train, or by dividing the passenger cars by a partition so as to secure separate accommodations. The case was presented in a different aspect from the one under consideration, inasmuch as it was an indictment against the railway company for failing to provide the separate accommodations. But the question considered was the constitutionality of the law. In that case, the Supreme Court of Mississippi had held that the statute applied solely to commerce within the state, and that being the construction of the state statute by its highest court was accepted as conclusive. If it be a matter, said the court, respecting commerce wholly within a state, and not interfering with commerce between the states, then obviously there is no violation of the Commerce Clause of the Federal Constitution. No question arises under this section as to the power of the state to separate in different compartments interstate passengers, or affect in any manner the privileges and rights of such passengers. All that we can consider is whether the state has the power to require that railroad trains within her limits shall have separate accommodations for the 2 races. That, affecting only commerce within the state, is no invasion of the power given to Congress by the Commerce Clause. A like course of reasoning applies to the case under consideration, since the Supreme Court of Louisiana, in the case of State versus Judge, held that the statute in question did not apply to interstate passengers, but was confined in its application to passengers traveling exclusively within the borders of the state. The case was decided largely upon the authority of Louisville N.O.N.T. Railway Company versus State and affirmed by this court. In the present case, no question of interference with interstate commerce can possibly arise, since the East Louisiana Railway appears to have been purely a local line, with both its termini within the state of Louisiana. Similar statutes for the separation of the 2 races upon public conveyances were held to be constitutional in Railroad versus Miles, Day versus Owen, Railway Company versus Williams, Railroad Company versus Wells, Railroad Company versus Benson, the Sioux, Logwood versus Railroad Company, McGuinn versus Forbes, People versus King, Houck versus Railway Company, heard